Welcome to the Regulatory Policy Seminar. I'm Joe Aldi, the Faculty Chair of the Regulatory Policy Program at the Mosavah Rahmani Center for Business and Government at the Harvard Kennedy School. Let me open with a few reminders regarding the logistics of our online seminar. We are recording this seminar and we will post it online. So if you know of someone who's interested but could not attend the talk live, please let them know that they can access the seminar at the MRCBG YouTube channel, and we'll post in the chat the link for you in a few minutes. You can also remind your friends and colleagues to register for Zoom links for each seminar at the RPP webpage, and we'll provide that link in the chat box for you as well. In today's seminar, we will take questions through the Q&A function in Zoom. So please click on the Q&A button at the bottom of the screen and type in your questions. At the end of our presentation, I'll take the questions and pose them to our speaker. Now, as many of you have been frequent attendees over the years of our seminar know that we've hosted a number of leaders in the practice of financial regulation, the comptroller of the currency, the chair of the CFTC. We've had those who've been involved in both legislative staff on the Hill, leadership positions in the White House who helped craft the Dodd-Frank Act of 2010. So we're thrilled to have with us today the Director of the Consumer Financial Protection Bureau, Director Kathy Kraninger. She'll present to us today her talk on current priorities in consumer financial protection. Director Kraninger has been the director of the CFPB since December of 2018. Before taking the helm there, she served as a program associate director in the Office of Management and Budget, where she oversaw the budgets for the Departments of Commerce, Justice, Homeland Security, Housing and Urban Development, Transportation, Treasury, and other agencies. A job that I'm sure kept her busy trying to oversee all those many agencies. Director Kraninger has previously worked on the staffs to committees in both the Senate and the House of Representatives. Earlier in her career, she worked at the Department of Transportation, and after the 9/11 terrorist attacks, she volunteered to join the leadership team that helped set up the newly created Department of Homeland Security. With that, let me say welcome, Director Kraninger. We're thrilled to have you with us here today.
Thank you so much, Joe. It is a pleasure to be with you all today, and I certainly appreciate the opportunity to present to such an esteemed group of academics, business people, and government officials. I want to also take a second to thank the Kennedy School itself, certainly the Regulatory Policy Program that you oversee, for organizing this seminar and inviting me to participate. As the New Directions in Regulation seminar series highlights, regulatory policy is a vast space. And the series covers everything from consumer financial protection, of course, where I sit now, to energy and environment, where you've spent a lot of time. It also includes dynamics with cross-cutting implications like artificial intelligence, which is overhauling consumers' interactions in the financial marketplace. So as such, these types of forums offer excellent opportunities to learn from and interact with one another. I'm excited for the opportunity to share some of the important and innovative work that we are doing at the Consumer Financial Protection Bureau. During my time with you today, I'm going to focus primarily on the role of economic analysis and evidence-based policymaking at the Bureau. I also want to address the role of research to measure the effectiveness of our rulemakings, as well as the role of research in our supervisory and enforcement work. And then I'll close by talking about how researchers like you can contribute to the Bureau's important work. And so I hope this presentation acts as a starting block for us to explore the various opportunities and connections among us today. So at the CFPB, we're always looking to effectively utilize our tools to protect consumers. Some of you may be very familiar with our work, but to others, the CFPB may sound like 4 more letters in the Washington alphabet soup. So in short, let me tell you that the Bureau works to prevent consumer harm in consumer financial markets, such as home mortgages and student loan. We strive to prevent consumer harm by working to ensure that consumer financial markets operate transparently, efficiently, and fairly. And our mission also includes promoting innovation in and access to such markets. The Bureau employs 4 main tools to support its mission. Education. So first, we empower consumers to make informed decisions about financial transactions through financial education. Second, we issue regulations that provide clear rules of the road for companies to follow. Third, we supervise financial companies to support a culture of compliance with consumer financial law. And fourth, we enforce violations and hold bad actors accountable to deter potential bad acts in the future. When it comes to developing and implementing policy, laws like the Administrative Procedures Act require agencies to outline their rationale for implementing or changing policy and undertake a transparent process to take comment on such changes. The law also dictates those reasons rest on solid evidence, including evidence of costs and benefits. At the Bureau, we adhere to and support good cause and evidence-based policymaking, not only to the extent that it is required, but also because the approach lays the groundwork for well-developed, thoughtful, and relevant policies. Researchers play an important role in economic analysis and evidence-based policymaking at the Bureau. The Office of Research is focused on providing the Bureau and its leadership with a picture of how our policy choices affect consumers, firms, and the economy. Our researchers have access to necessary data resources to develop a full understanding of what is happening in consumer financial markets. And most importantly, our research is integrated into policy teams to help us connect economic analysis with the policy decision-making. Of course, our policy-relevant research does not exist in a vacuum. Evidence-based policymaking means engaging with researchers outside the Bureau, and we want to incorporate the distinct and unique perspectives of this outside research into our own work and policy development. We recognize the negative effects of research silos, so our academic outreach is truly meant to prevent the building of silos and to facilitate that kind of collaborative work. So let me provide a few examples of how our researchers support the important mission work of the Bureau. Since I arrived at the Bureau, I've focused on actions we can take to make sure consumers are better prepared to respond to financial shocks. The Bureau's Start Small, Save Up initiative is designed to help educate consumers about building an emergency savings account in particular. To succeed in this effort, we need to understand the challenges consumers face in their financial lives. These issues have become more urgent this year as the financial lives of millions of Americans have come under stress. So our research in the areas of emergency savings and consumer challenges in building emergency funds has been informed by a unique data source that the Bureau has available to us, and that's our Consumer Credit Panel. The Consumer Credit Panel is nationally representative with a 1 in 48 sample of de-identified consumer credit information. Building on this data set, we recently conducted a unique consumer survey we refer to as Making Ends Meet. We asked a nationally representative sample of consumers about their preparation for financial setbacks. We also asked about financial shocks they'd experienced and how they responded to those shocks. We conducted a second wave of the Making Ends Meet survey in the spring. And through the second wave, we're actually looking at what results tell us about how current financial stressors have affected consumers' lives, and particularly their financial lives. We're also planning another wave of the survey that will tell us more about consumers' financial preparedness, as well as their experiences during the current period. So certainly keep an eye out for those Making Ends Meet surveys and our reports of them. It's really been a phenomenal look, and particularly given the impacts of the pandemic and the timing of our survey, it was certainly well timed to give us some additional insight here. Next, I'd like to talk about the role of research in the rulemaking process. The Bureau's economists are an integral part of each rulemaking project. Economists on any given rulemaking project identify, develop, and analyze evidence relevant to the costs and benefits of the rules under consideration. Disclosures in the debt collection market is one area where we have a pretty robust rulemaking effort ongoing. And we face important questions about how to effectively disclose to consumers debt-related statute of limitations rules. As you may know, statutes of limitation define when an unpaid debt is old enough that a debt collector may not be able to enforce the debt in court. To determine if or what type of debt collection disclosures would be effective, particularly given the myriad rules around this and laws around this across the states and across the country, the Bureau used a tool you know well, quantitative testing. Specifically, we conducted a large randomized online survey in which we showed participants various disclosures versions. We then asked questions to test their understanding of the information in the disclosures. The level and specificity of testing that we conducted demonstrates our commitment to investing the time and resources necessary to develop develop the evidence that we need to answer these important policy questions, and frankly, support, again, that increased consumer understanding, which is the basis for even engaging in rulemaking in this area. In addition to the testing, it's important that the Bureau be as transparent as possible about how we conduct this research. This transparency helps us avoid the research silos that I mentioned earlier. This year, the Bureau also introduced a process of peer review for studies that it expects will play an integral role in policymaking. In the case of the debt collection disclosures, we sent the study for external peer review. While this peer review process will be familiar to you, it is important to emphasize that the CFPB is using this process to aid us in our policy and decision-making. The referee report from the external peer review is also publicly available on our website. And currently we're working on a response to the referee report, which we will also make available on our website. Going forward, this transparent process will give all stakeholders more confidence in the research that informs our decisions. And certainly as the decision maker in the agency, this is incredibly valuable to me to really make sure that we are developing the most robust processes, that we really have the right information to make these kinds of decisions, and again, improve the way the markets function for consumers. Next, I want to talk about the role of evidence and research in understanding whether our existing rules are effective. As background, the Dodd-Frank Act requires us to review some of our rules within 5 years after they take effect. These reviews are called assessments. Thus far, we've conducted 4 assessments of some of the Bureau's most important rules. In the most recent assessment, released earlier this month, we looked at the Bureau's TRID rule. This rule was designed to streamline the information consumers receive in the process of obtaining a mortgage loan. Congress required the Bureau to consolidate the overlapping disclosures that were previously required in the Truth in Lending Act and the Real Estate Settlement Procedures Act, or TILA-RESPA, which gets you to TRID. In response, the Bureau developed new forms with the goal of improving the process. And the assessment provided us the opportunity to dig deeper into the ways that the rule has and has not been working for consumers in the market. I want to emphasize that we see assessments as opportunities. Among other benefits, they permit us to take this careful look at the benefits and costs of key requirements. So I'd like to just talk briefly 3 additional points on the assessment program. First, assessments are not pro forma exercises. For this most recent assessment, a team of economists began their work in early 2019. The assessment included careful analysis of multiple administrative data sets on mortgage lending. In addition, the Bureau collected new data specifically to support the assessment. We also reach out extensively to industry and consumer advocacy groups, the public, to provide any information they may have on how the rule is working and to inform the assessment. Second, when we conduct assessments, we are transparent about our approaches and methodologies. This most recent one, we published a notice in the Federal Register inviting comment on our approach to the assessment. And we considered the public's input as we designed the study. When we published the assessment report, we published details of our methodology to allow really the public at large to see how we came to our findings. Third, the research conducted for our assessments can act as input for our ongoing policy work. My staff's currently evaluating the findings from this TRID assessment, and the evaluation's already providing useful policy insights. Specifically, the integrated disclosures may be a good candidate for our trial disclosure sandbox. The trial disclosure sandbox is a program designed to improve disclosures through community testing. For example, the program would permit a community bank or other mortgage creditor to test for a limited time alternatives to the current disclosures. The larger point here is that our assessments are definitely worthwhile undertakings, and they're big undertakings, both in terms of what the Bureau expends and what the public expends. And it's really meant to suss out the effectiveness of those rules. Are they operating the way they should? And what opportunities are there for improvement or change? And certainly our trial disclosure sandbox is something that I'm really excited to see operate, excited to see these opportunities, not just for what the disclosure says, but you have a lot of different opportunities for when in the process that information is provided to consumers. There's been a lot of discussion in the disclosure space around just-in-time information. When we get overloaded, particularly if you all recall going back to mortgages that you have signed here, it's a stack of paper you get at the end. You know, what information do you really need? When in the process? How do we take advantage of technology development here as well to get that information to people at the right time and in a way that they'll actually read it? So I think there's a lot of opportunity for improving things here. And to give you a sense of how our assessments can inform policy, let me give you another mortgage rule example. You may know we're considering amendments to the Bureau's qualified mortgage rules. The qualified mortgage rules are meant to ensure mortgagees can repay their mortgages. The Bureau first issued in 2013 a rule addressing consumers' ability to repay their mortgages. And we published an assessment report on that rule very early 2019. It was, in fact, one of the first things that I approved as director of the agency. When we proposed amendments this summer, we cited some of the findings from the assessment among the evidence that supported the proposed changes to QM. And in this case, the assessment provided the Bureau with a clearer understanding of the rule's effects, and that continues to be important as we evaluate the public's comments in response to the QM proposals. Finally, I want to discuss the role of research in supervision and enforcement, and specifically discuss the work that our economists do to support the Bureau's fair lending mission. The Bureau is responsible for ensuring compliance with two fair lending laws, the Equal Credit Opportunity Act and the Home Mortgage Disclosure Act. We do this through our supervisory work and through enforcement. The Bureau's fair lending supervisory exams cover a wide variety of markets, including mortgages, auto, credit cards, student loans, and small business lending. Examiners review multiple parts of a lender's business. They conduct transaction testing, where examiners review loan applications in granular detail to ensure that all regulations are followed. And fair lending exams also involve statistical analysis of a financial institution's transactions. And this part of the process is one where our economists are heavily engaged. One important purpose of the Bureau's fair lending analyses is to determine whether legitimate differences in creditworthiness across demographic groups explain disparities in the outcomes we observe. And if the disparities in prices or other outcomes are explained by legitimate factors. So during our supervisory work, we explore all legitimate explanations for lending outcomes to fully understand those disparities or any disparities. Our economists are involved from beginning to end. They conduct initial analyses of the financial institution's data to identify areas of risk and narrow the focus of the exams. Through these efforts, they conduct statistical analysis to estimate statistical disparities, and if needed, identify harmed consumers and estimate restitution amounts. Our economists have access to lenders' policies and procedures, so they know what factors a lender should be considering when making the decision and how the lender should consider these factors. I emphasize should because the problem is sometimes that an institution's lack of it is sometimes the lack of adherence to the institution's policies and procedures to begin with. Our economists also have access to the lender's application level electronic data. Given the importance of the economists' analyses and frankly, these statistical analyses to fair lending work, it's vital that institutions understand what we're looking for in these types of exams. And our efforts to maintain transparency here include publishing the methodology that we use, frankly, so institutions can do the same type of analysis themselves and have good, robust compliance systems that take a look at any corrections that might be needed and look at disparities. Examining a company's data for fair lending purposes is something that other government agencies actually also do. And so as we looked at this, and I personally looked at this, I said, do we know what methodologies other agencies use? Do we have an understanding of that analysis and how it's conducted and where there might be differences in our approaches and what drives those differences? So to that end, the Bureau began a conversation with other agencies that do this kind of work to really try to bring that transparency to light, even just within the government family. At this point, we're not talking about sharing that publicly yet, but just understanding what agencies are doing amongst themselves. And that's something that I'm sure all of you who have served in government can appreciate. It's always harder than you wanted it to be or expected it to be. But I can proudly say that the result of this is an MOU that is launching a working group to actually sit down, and the economists are going to be voluntarily sharing their analytic methodologies, how they approach this, and how we assess compliance with fair lending laws. So as those of you in academia also know, testing ideas with other experts is essential to improving our methodologies and analyses. So before concluding my remarks, let me come back to what I was saying earlier about how researchers can engage with the Bureau. First, we have a number of opportunities for direct engagement. Most pointedly, first and foremost, we have an academic research council where folks apply to be members of that council. And in fact, I want to take the opportunity to thank Karen Dinan, too, of Harvard's economics. She just finished her term on the Academic Research Council, but it is a small and austere group of outside experts who are engaged with us as advisors, frankly. And so it's a really great opportunity for folks to really engage in a very meaningful way, and with me too. We also have a program through which academic researchers can spend part of their time working directly with us. So opportunities for postdoctoral fellowships and other types of positions like that. Second, we're keenly interested in research conducted outside the Bureau that is relevant to the decisions that we're facing. Few examples on that in terms of the questions we're looking to answer. What information about financial products is most important to consumers, and how can it be effectively disclosed? Talked about that a little bit earlier. Why do many consumers have less emergency savings than they think they need? Is there information creditors can use to assess creditworthiness that will improve access to credit, particularly for consumers who appear credit invisible? What drives continuing age, gender, and racial disparities that we see in financial outcomes? How can we better detect and measure the benefit of consumer financial protection rules in order to conduct effective cost-benefit analysis? So we really want to encourage academic researchers to pursue these questions. We want you to know that new knowledge in these areas can have a huge impact on decisions that we're making right now. And one way we do this is also by hosting academic research council conferences that we do every year. Our next conference is actually scheduled for May 6th and 7th, 2021. And the call for papers was posted last week. So we look forward to supporting a wide range of submissions there. And certainly the last thing I will say is that we are hiring. The Bureau currently has open positions for economists in the Office of Research. We'll be conducting interviews in connection with the ASSA meetings in January. So please encourage interested students. As I've tried to convey today, the Bureau offers economists tremendous opportunities, and not only for great data resources and phenomenal colleagues and a great boss, but it also offers a special opportunity to have direct impact on policies that can help millions of Americans and consumers across our country. So Joe, I certainly want to thank you for the opportunity to be here, and look forward to furthering the conversation.
Great, thank you, Director Kraninger. It's great to hear that you're hiring. This is something that some of our doctoral students across the university are thinking about as they're looking at the market going forward. So we will certainly pass along that good news. I will also note, I've enjoyed the opportunity to participate in a CFPB academic conference about a half dozen or so years ago. Not that I do work in financial regulation, but I've done work thinking about retrospective review of regulations. And as you noted, and we'll get into this, I think, some in our Q&A and discussion, what an important role that is at CFPB, and what's actually quite distinctive in Dodd-Frank in providing that mandate to do that kind of regulatory performance evaluation. But first, let me remind everybody to use the Q&A tab at the bottom of Zoom to write your questions. We'll get to those in a few minutes. But before we do that, I want to turn to our colleague from the law school, Hal Jackson. Professor Jackson is the James S. Reed Jr. Professor of Law at HLS. His research focuses on financial regulation, consumer protection, international finance, and federal budget policy. Hal served as a visiting scholar at the Consumer Financial Protection Bureau from 2013 to 2015. Hal has presented in the past in our seminar. He is a frequent attendee as well, and it's great to have him here to share some initial thoughts and comments on the director's remarks before we turn to the Q&A. Hal?
Great. Thank you very much, Joe, and thank you, Director Kraninger, for coming to Harvard and continuing, a longstanding relationship between the Bureau and Harvard University. It's great to have you back. And as Joe mentioned, I have been a beneficiary also of your academic outreach. And in fact, what I did when I was a visiting scholar was work with one of the economists in the RMR, the Division of Research, Marketing and Regulation, as it was called at the time, on analyzing cost-benefit analysis statements, particularly benefit analysis at the Bureau. And as the director indicated, the Bureau is a very unusual agency in that, being created in 2010, cost-benefit analysis was hardwired into the statute, both in the so-called 1022 cost-benefit reviews that are done for all the regulations, and then also this retrospective review assessment process that the director was referring to, and on which Joe is an expert. And I think that does make it more attentive to empirical evidence, and there are other agencies around the world. I think the UK's FCA, which does market studies first and then regulation second. It's sort of fulfilling what I think Director Kraninger has talked about in other areas, which is to figure out what the market failure is before you adopt the regulation, and then you have a baseline from which to evaluate, how you have improved, hopefully, the market and what the benefits exactly are. And I think the Bureau has done, a very good job about getting the expertise developed over the past, nearly a decade now, to have that kind of baseline information. So I think it's a model, and the study that I did with Paul Rothstein from the CFPB, demonstrated even early on, the Bureau did more complete cost-benefit analysis than most other financial regulators, and actually was comparable to executive agencies who have kind of been in the business for a long time. So it's kind of, sometimes the law makes a difference, and I think that did here. So I thought I'd just raise a couple of issues to get reactions from the director about, some complexities. So one of the challenges in the consumer space, and this is a little bit written in the statute too, is the insights of behavioral economics, and the fact that, the standard economic models may not completely predict the behavior of consumers, and sometimes consumers behave inconsistently at a minimum, and maybe not in their best interests or in ways that they regret later. And that, that's certainly a possibility and a possible justification for regulatory intervention, but it makes it kind of difficult to assess the benefits that you're generating because revealed preferences, as we kind of say, have what might be thought of as mistaken choices. And so how you think about improving consumer welfare is tricky around behavioral economics. And this is a topic that in an academic seminar is sort of a mind twister, and you can sort of go back and forth about. But in real life, someone in the director's position has got to decide when there's a benefit on the behavioral economic side. And I'd sort of like to hear a little bit about how the director thinks about that issue. The Bureau had a roundtable on this topic recently, if anyone wants to Zoom watch it, but I'd be curious about the reactions here. Another question that I have that's implicit in what you said, but the way cost-benefit analysis is used in the statutory requirements is in regulation. but as the director noted, there's regulation, supervision, enforcement, and financial literacy education. Oftentimes, the director is choosing which way to go. We only formally do CBA around regulation. And I appreciate that the economists get involved in fair lending activity, but it's sort of a separate question of, did supervision work? Did enforcement work? Did financial literacy actually get the benefits that we might have achieved in other ways? So I'd be curious about how she thinks about deploying these tools across the toolkit. So that's two questions about cost benefit analysis. We do things in threes here, so I have a third one, which is
I got to start writing this all down now, Al.
Yeah, well, the nice thing about having three is you can pick the one you like the most. And there's been a lot of legal discussion about political control over the Bureau, and it's kicked up to the Supreme Court, and we now have guidance and clarity that tweaked things a little bit about removal power, which is rarely invoked, but now it's clear. But there's a separate question about organizational structure at the Bureau, which has evolved a lot over time. And every time I look at the org chart, it looks a little bit different. But one particular piece that's interesting is the interposition of political appointees and career appointees. So, at some point, when you step down and meet your successor, what advice will you give them about how much political oversight is necessary to help you do your job, and how much is too much for the, stifling the expertise and traditions that grow up in the agency? So how should we think organizationally about the line between the politics and the economists and lawyers and the other folks that kind of are the Bureau, on an ongoing basis? So those are three questions, and bonus points for answering all three or speaking to all three. But it's great to have you here, and thank you very much for your remarks.
Thanks,
thank
Al.
you. And again, go ahead, Joe.
Kraninger, I would like to make an amendment to the last question, because you've worked at OMB as well, where in your position, you were a political appointee overseeing a very talented, some of them are graduates of our program, so we tend to like to say that, a very talented career staff at OMB. So I'd be interested to hear your thoughts as well about being on both the OMB side, and in fact, previously you were in agencies, as well as now that you're an independent regulator, how you think about this relationship between the political appointees and the career civil servants. So with that, we'd love for you to address 1, 2, or 3 of Hal's questions. So I'll let you take it away.
I am happy to. I'm one of those people that never dodges a question, so I'm happy to at least touch on all three to the extent that I can in a limited way. But they're obviously big questions with a lot of people answering in a lot of different ways. But starting off with behavioral economics, Hal, as you mentioned, we obviously did a symposium precisely on this topic and understanding what the role is there. And I will say we've had a history of and continue to hire researchers in areas across the spectrum here. And so there is a place for behavioral economics in our research space, particularly certainly in the policy making, evidence-based information that comes my way as I make a decision. So I think probably the other two questions are probably of deeper interest to me than the first one. So I'll at least start with that it's very much, I think, important to bring different disciplines to bear and to bring different factors to bear. And certainly disclosure testing is a great example of it too. We're trying to, increase consumer understanding as the area where I've spent a lot of time on this. And so that there is absolutely a role for, how exactly to approach consumers. And again, my interest in timing, which we really have not spent a lot of time on that topic, I feel like, in this area. But the timing of when the disclosure comes, I think there are a lot of behavioral elements that could be taken into account on that. And so I really am pushing staff to think about this as we design the work that we're doing there. But probably given 3 robust topics, I'll pause on that one. With respect to cost benefit analysis across the board, again, this is something that I just believe fundamentally is important to policy making. Now, did that make a lot of people, particularly those who are detailed in understanding what 12866 actually requires, what for a regulation, what does that mean in every other facet? And we had a lot of discussion about that, because when I said cost benefit analysis, even in the assessments, that made a lot of people nervous. And we had a whole discussion about what you can actually quantify. You all know, in looking at regulations across the government, there is a lot of cost benefit analysis that just is not particularly quantified, particularly on the benefits front, how we quantify that. It is really challenging to do. So I'm even just pushing for that as a rubric for the academic conversation. Cost benefits don't have to be necessarily quantified if you can't quantify them, but even the qualitative notion that there are pros and cons and what exactly those trade-offs are, that to me is the very nature of the policymaking process. So more rigor behind that, more evidence base behind that is certainly what I'm seeking. And that includes not just our regulations, but the opportunity in financial education is one area in particular, trying to figure out what is effective, what we should actually invest in more, how to approach people and when. In the supervision and enforcement space, we have had that discussion, and how, frankly, maybe when you were here, you even saw a little bit of that dance. What role should the economists play in that process when it comes to even the rigor around assessing what a penalty should be? Looking at, again, the resources of an institution and a lot of trade-offs there. I've certainly had a number of conversations with members of Congress around that particular topic, but it is of interest to me, again, to have a framework for how to think about that, more rigor for how to think about that. And the Bureau absolutely has been maturing that throughout its history, and including in my tenure. So we're going to continue to do that and try to bring some of that rigor to the process, and the economists can certainly help. So when I think about cost benefit analysis, it is in a very broad sense, again, the rigor and framework for how to make better decisions and bring evidence to bear to that. And then the last question, again, on this political career dynamic, I can tell you I've been in government for more than 20 years now. I started as a Peace Corps volunteer, so there's no, in terms of a Schedule C appointment, it's not a Schedule C appointment. Obviously, we're all equal when we go out in Peace Corps. But my jobs in DC have almost all been Schedule C positions. So that's at actually now 4 agencies in the government directly. And so it's been interesting to watch this evolve. I truly am dedicated to public service. I believe in it. I believe, again, in this debate that we can be having, and the most frustrating debates I watch or am part of is when we're debating the facts. That always concerns me, because I'd like us to have a common understanding of the facts in which we're operating, and then again can debate the right way to approach the facts or to solve whatever problem we've all agreed is the problem. And I think that's one of the challenges with the dynamic today. I have had, again, great opportunities to work with career officials across the spectrum. I have particularly never cared where exactly someone was coming from, if they came with a good idea and a good reason for it. So Joe, you mentioned OMB. Obviously, your time at the White House too, you worked with OMB quite a bit. It is a true gem in just the government in general, of how you bring some really just high quality, motivated, smart staff. It's a little bit of a microcosm of the whole government. And so they're really dedicated to even some of the conversation we're having today. They'd love it. That's why they also love going to the Kennedy School. But all of these things about cost benefit analysis and how you bring evidence to bear in policymaking, they love the mission. And I can tell you that is absolutely true here at the CFPB. We have staff that love this mission, and they all come at it from different perspectives. And that's part of the process too, is bringing those perspectives and that debate to bear. So I think the last thing I would just note is obviously we do have a political political oversight of the career civil service. That's part of the system. And I think it's an important part of the system. We're accountable to the people. And that's the mechanism through which we're accountable to the people. And that transition and that smooth transition, again, whenever it comes, is absolutely something I support and will support and always have supported. So hopefully that helps cover all three. I get some extra points for that.
So I would not be surprised if Hal has follow-ups. Maybe he'll bring them in another set of three. We'll see. But Hal, feel free to jump in again in a moment. But Director Kraninger, I'd like to follow up on your comment about working with other financial regulators. This is a regulatory space. We're very American about this in contrast to some of our peers around the world. We have a lot of different regulatory agencies covering different elements of the financial domain, some of which where there's some overlap, there's some need for coordination. There's also opportunities for learning. So some of our financial regulators have not historically had the interest or enthusiasm or the practice in conducting analysis of the rules that CFPB has had. And that's just not my opinion. That's also the opinion of judges that have ruled on them. And I am talking about you, the SEC. So they have been trying to, I think in recent years, improve the way they do this. You're a young agency among the alphabet soup, some of which have been around now, almost a century or more. Are there opportunities where you find where you can actually share some of what your team is learning in terms of how you conduct the analysis to better understand the potential implications of a financial regulation or an information intervention? Is there also some sharing going on and learning among the financial regulators at that level so that we have a better sense of evidence across the board for the kind of regulatory actions they take?
Yeah, I think, again, that is a great question. I'm going to take it up for a second and then get back to the detail that you were asking about, because I do think, look, I've worked in the interagency space my whole career as well. And in that overlap, and even, the creation of the Department of Homeland Security was probably my my earliest experience with this, because it took parts of a lot of different government agencies, but of course left tentacles. And so how you maintain those relationships, how you actually carve out roles, responsibilities in that space. And so coming actually to the CFPB, when I did, that is still very much a work in progress. We're not even 10 years old. And there was a lot of, certainly a lot of activity. And I don't say negatively disruption. I suppose there's positive and negative to disruption. A lot of disruption with the creation of this agency and the changes, excuse me, and the changes that happened after the financial crisis in how we regulate. So we're really, we've come out of that. The pandemic has been a huge opportunity to work together. And I am really encouraged by that too. I think we have really agency heads at this point and chairs at this point who really do want to work together and make sense of this, because we think it works best for the economy and for consumers. So there really is a lot of energy on making sure that we are comparing notes. And I'm sensitive to, and I said it with the fair lending analysis, I'm not even seeking for us to literally have the same methodology. I'm just looking for us to share methodologies. So there are some baby steps that are involved in these kinds of processes, but it is important. And that's true on the cost benefit analysis side. We have talked about it. We certainly look to do things jointly. We've had really actually in the housing space with the pandemic too, just really significant gains. We obviously had staff from HUD that came over to the CFPB when it's created. FHFA, again, was also, again, a financial crisis creation. So in terms of how it operates, some things that were different there. But our work with HUD and FHFA on really all the guidance to servicers in this time period, all the outreach to consumers, that has been a huge level of work. And so it's not necessarily cost benefit analysis, but it is data sharing in a broader way than we ever have before, in a more systematic way, because that's also something that I've pushed. I think the Bureau has some great relationships, but some of them are person-centric just because of, it's not mature, it's developing still. So the opportunity to make those systematic and really embed those in the way we operate, and data sharing is one of the ways we can do that. And so certainly our complaint data was something we could offer to FHFA that FHFA had actually never thought to access before. We share it with a lot of other agencies, but we had never shared it with them. So that's been something that's been happening as a result of the pandemic that I'm excited to continue to build on and see what we can do together.
Great. So to follow up on that, we had a question from one of our attendees about a 2018 request for information about the consumer complaint database. And so they're kind of curious what, if any, changes were made in response to the feedback that the agency received, and what may be some of what you may be doing going forward with this database. And finally, are there any outside research projects attempting to use this database to help provide the foundation for future evidence-based policy proposals?
Excellent questions. So we did obviously do that information request to look for opportunities to continue to make improvements. I actually have a really forward-leaning staff that manage that entire system. We call it the Office of Consumer Response, that has a responsibility for managing that system. And they're just a really dynamic group of people with a dynamic leader. So thinking about how do we constantly improve? How do we make sure the information we take in is analyzed in a way that's useful to the use of the agency itself? And that's something, at least in my messaging, that I have emphasized repeatedly, and that came through here. The point is, the data is only as good as it's actually used to take action and used as information. I'll note to you there are some quirks about this because our attorneys have determined that is not actually data pursuant to the Evidence Act. So there are some dynamics around that. It's not data, but it is useful information from my vantage point for making sure that we are taking fast action. We are having some insight into what's happening in the marketplace, albeit in a way that is narrow, because we're talking about the people who are most aggravated by whatever experience they had. And so we're not talking about necessarily widespread vantage point of what's happening across the market, because it's the subset of the subset of the subset of people who are clearly having an issue. But again, that's useful. It's also useful comparing it against itself over time to see how that may be changing and who that might be changing with respect to. So that was one area where we wanted to make sure we were clear on how we talk about and frame the database, that it's not the end all be all. It's a slice of what's happening in the market, again, to those people who are most affected by an experience they had, but it's useful. And so explaining how we use it to inform our supervision and enforcement work. To the extent that we see an entity that is particularly a repeat issue there, we see a lack of responsiveness from particular entities, that's something we're going to actually go in and look at via supervision or enforcement when that is the right tool to choose. Education, hugely beneficial in our education efforts, because, for example, early on in the pandemic, we saw a huge spike in consumer complaints related to people saying they weren't able to pay their mortgage and make their mortgage payments, but they were confused about the options that they were told and what options they had. And it was really early on. So it was even while the CARES Act was being proposed, then right when the CARES Act passed. So you can see, again, everyone was struggling with, how do you explain this? What is the right? Doing interpretation work at the same time that people are calling in seeking assistance. And so we really engaged very quickly, again, with FHFA, HUD, others. We did servicer scripts. We did videos for consumers so they knew what their rights were. That really helped the servicers and lenders because they were sharing that video with their customers. So it was a very crisp way to kind of get that out. And we saw those complaints come down very dramatically and what we would hope would happen. So again, it's an indicator, at least, of how we can take action and address the issue and change again the nature of the kinds of things that are coming in. I will say the credit reporting space is a space where we continue to see a lot of complaints, and we're going to actually undertake a deeper study on that in particular, because the last time a study was done, it was by FTC, I think almost 20 years ago at this point. And the CFPB has spent enormous energy, particularly through supervision and through enforcement. We had the Equifax case, in what are we doing to work within this system and make sure that accuracy is first and foremost, see where so we're going to actually look at what has changed, what impact has our effort actually had in this space, what more do we all need to do? And of course, it's only as good as the data the furnishers provide. So we've spent a lot of time on the furnishing side of that system too. But we continue to see complaints. And so trying to figure out what additional action might be necessary there is part of what this effort will be, but very evidence driven. So a little long-winded question, I suppose, on all things consumer complaints, but an important area.
Great, thank you. Let me turn to Hal for a moment. Hal.
Great. So I would like to go back to the fair lending discussion that you raised earlier. And it's a very interesting and important area of the law, particularly right now. And you were just describing, as I would say, the supervisory approach, which has been the traditional approach, maybe supervision followed by enforcement. The Bureau actually has done what I'd call ex-ante review of some of these new AI technologies to kind of pre-clear, and especially with machine learning and AI that might find different credit factors to reach the underserved. That has some advantages. Of course, it puts a burden on the Bureau to have the capabilities and the methodologies to pre-clear, and maybe some policy questions about whether what you're pre-cleared for and how long you're pre-cleared. But how do you think about that as a regulatory innovation of helping new technology and small companies that might be a little scared to get into this business if they're going to be facing a whopping fine afterwards if it turns out that the supervisors don't like what they do? So
yeah, that's a great question, and to the heart of course, the innovation policies that we've put out there, which is the mechanism by which we're doing the process you kind of described. I described a little differently, which I will do, but just in terms of that, it is a complex space. There's no doubt about it. And there are some pretty high bars to any new companies coming into the financial services space. Also, given the regulatory framework, as Joe so artfully laid it out, it is myriad. So trying to come into this space is I think what we were recognizing, and frankly, we're not alone. I know that the Fed actually recently stood up their innovation staff, had an innovation head come in. The OCC was the first, frankly, so we worked really closely with them. We were the second. FDIC has some folks working on innovation. They've been trying to hire an innovation head, so I'll throw that plug out there too. At any rate, those things are, and trying to do that together and really think about how the interplay works. Our innovation policies are based on our supervision and enforcement authorities. So it is basically an exercise of discretion and assuring an entity, once we have an understanding of how they're going to operate, what the product is specifically, how they're going to operate, how they'll ensure compliance with the law, that again, as long as they're operating consistent with the policies, we wouldn't take action against them while they're under those policies. And it is, I know there was a lot of concern early on, particularly around fair lending. Interestingly enough, the only policy that the Bureau ever approved under Director Cordray's tenure was one on fair lending. So that actually is, I think it is a notable step there that says, hey, we'll take on issues that are a little thorny. We are continuing to look at that. It's a company that is exactly in the space that you noted that is a little thorny in terms of how to use other factors into underwriting. and using machine learning to do that. And so, really, it's about the way that the company, moving away from that particular example, but the way the company that looks at the factors that are coming in and how they make that decision if they're bringing other factors in a way that's going to be beneficial to consumers and is not a means by which you could actually decline credit. So there are a lot of things in this that are devil in the detail specific to a particular product. But we're just excited to be engaged in that conversation. It gives us a lot of insight to understand how the market's looking at this, how fintech companies are looking at this in particular, and banks that want to partner with them who are looking to do something a little bit different. So that has been very valuable in increasing our understanding of what's out there. And look, these are clearly entities that want to comply because they're coming to the government to begin with. So that's something else that we took into account. We put a lot of guardrails in our policies, but we're recognizing, again, it's entities that want to comply with the law because they're coming forward to us. They think they have something that's consumer beneficial. We have to agree. And we also have to agree that they're mitigating the risks that might exist, again, to fair lending compliance or otherwise.
So it's now 1 o'clock. I wish we could continue, but we do need to wrap up. Some of our attendees I know will be going to a different Zoom room for class. So before we wrap, a couple of quick comments. First, a reminder that the seminar will meet again next Thursday. And in fact, on a topic related to what the director was just speaking on, we'll have Michael Fitzpatrick, the head of global regulatory affairs at Google, speaking on the challenges and opportunities of artificial intelligence and digital policy over the next decade. That will be, as usual, 12 p.m. Next Thursday, November 5th. A personal note, we are getting our closing disclosures for our new home purchase this afternoon from our bank. I look forward to seeing the new forms, at least new relative to the last time we were in the business of getting a mortgage. In fact, I do sometimes teach in my economics course on information disclosure. And in fact, using the old Lacko and Papalardo paper in the AEA papers and proceedings about how they tested different kinds of disclosure instruments and see how well people understood it. So hopefully between my preparation for teaching and what I've learned generally and today's seminar, I'll be able to process what it is we're taking on with our new mortgage. Finally,
I hope so. Joe, you'll have to let me know.
Okay, I will. Finally, I've really enjoyed this. I hope everyone else has as well. So I'd like everybody to join me in thanking Director Kraninger for her presentation and discussion today. Thanks, Director Kraninger. Let me also thank Professor Jackson for joining us. Hal, a pleasure as always to have you here. It's great to have all the attendees here, including my mom. Hi, Mom. Thanks for joining us today. But I hope that everyone enjoys the rest of their afternoon. Thanks again for joining us. Take care. Bye-bye.
Thank you all very much.